Today, we're going to delve into one of the most powerful and visible areas of law, criminal law. When we think of law, we often think of crime, murder, theft, fraud. But criminal law is much more than a list of prohibited acts. It is the system through which the state expresses its core values and exercises its most awesome power. The power to deprive a person of their liberty, their property, and in some jurisdictions, even their life. At its heart, criminal law is a system of social control. It defines what conduct is unacceptable and prescribes punishment for those who engage in it. But unlike civil law, which deals with disputes between private parties, a criminal case is brought by the government, the state, or the people against an individual. The question we begin with is, what makes an act a crime? Before we look at specific crimes, we must understand the principles that underpin the entire system. A. The principle, legality. There is no crime without law. This principle, encapsulated in the Latin maxim nullum crimen, nulla puna sine lege, means that a person cannot be punished for an act that was not clearly prohibited by law at the time it was committed. Ex post facto laws, laws that criminalize conduct retroactively, are forbidden. This ensures fairness and allows people to know what is expected of them. B. The burden of proof. In the American system, a defendant is presumed innocent until proven guilty. This is not just a nice idea, it's a constitutional right. To overcome this presumption, the prosecution must prove every element of the crime beyond a reasonable doubt. This is the highest standard of proof in our legal system, reflecting the severe consequences at stake. Think of it this way. In a civil case, example, a contract dispute, the standard is a preponderance of the evidence, meaning it's more likely than not, just over 50%. In a criminal case, the standard is beyond a reasonable doubt. It doesn't mean beyond all possible doubt, but it means that after hearing all the evidence, the jury must have a moral certainty of the defendant's guilt. If they have a reasonable doubt, their duty is to acquit. 3. The anatomy of a crime. Every crime is composed of distinct elements. For the prosecution to win a conviction, they must prove each of these elements beyond a reasonable doubt. They are typically broken down into two parts, the actus reus and the mens rea. A. Actus reus, the guilty act. This is the physical, external component of the crime. It can be 1. An affirmative act. This is the most common. For example, pulling a trigger, taking money from a cash register, or punching someone. 2. An omission, a failure to act. Generally, there is no legal duty to rescue someone. However, a person can be criminally liable for failing to act if they have a special duty. Examples include a parent failing to feed their child, a lifeguard failing to attempt a rescue, a person whose own actions created the peril, example, starting a fire, and then failing to call for help. The act must also be voluntary. A reflexive action, a seizure or being physically forced by another person, overcome by superior force, does not constitute a voluntary act. B. Mens rea, the guilty mind. This is the mental state of the defendant at the time of the act. It's the intent or knowledge that makes the act blameworthy. The Model Penal Code, a template used by many states, defines 4 levels of culpability, from highest to lowest. 1. Purposefully. The conscious objective is to engage in the conduct or cause the result. Example, I bought a gun, waited for my enemy, and shot him because I intended to kill him. 2. Knowingly. The person is aware that their conduct is of a particular nature, or that a result is practically certain to occur. Example, I set off a bomb in a crowded building to destroy a safe, knowing the explosion would certainly kill people inside. 3. Recklessly. The person consciously disregards a substantial and unjustifiable risk. This is a gross deviation from what a reasonable person would do. Example, firing a gun into the air in a crowded city on New Year's Eve. 4. Negligently. The person should be aware of a substantial and unjustifiable risk, but fails to perceive it. This is a gross deviation from the standard of care of a reasonable person. For example, a hunter firing a gun without checking what's beyond the target. It's important to note that a crime can require different mens rea for different elements. For example, a burglary statute might require that a person knowingly enters a building with the purpose to commit a theft inside. C. Concurrence and causation. Concurrence. The actus reus and mens rea must occur together. A person cannot accidentally hit someone with their car, no mens rea, and then later form the intent to kill them, no actus reus at that moment, and be guilty of a single, combined crime. Causation. For result-based crimes like homicide, the defendant's act must be both the cause in fact. But for the defendant's act, would the result have occurred? And the proximate cause was the result or reasonably foreseeable consequence of the act. If an intervening event is highly abnormal or unforeseeable, it may break the chain of causation. 5. Types of crimes. Crimes are generally categorized by their severity. Felonies, the most serious crimes, punishable by or imprisonment for more than 1 year, typically in state prison. Examples: murder, rape, robbery, arson. Misdemeanors, less serious crimes, punishable by a fine or imprisonment for up to 1 year, typically in a local jail. Examples: petty theft, simple assault, disorderly conduct. Violations, infractions, minor offenses, not considered crimes in many jurisdictions, punishable only by a fine, no jail time. Examples: traffic tickets, jaywalking. We can also categorize crimes by the interests they protect. Crimes against the person: homicide, murder, manslaughter, assault, battery, rape, kidnapping. Crimes against property: larceny, theft, burglary, breaking and entering with intent to commit a crime, robbery, larceny by force or fear, arson, fraud. Crimes against the public: drug offenses, public disorder, weapons charges. If the prosecution proves all the elements of a crime, the defendant may be found not guilty if they can establish a defense. Defenses fall into 2 main categories: failure of proof defenses and affirmative defenses. A. Failure of proof defenses. Here, the defendant argues that the prosecution simply cannot prove an element of the crime. For example, alibi: I wasn't there. If true, the prosecution cannot prove the actus reus. B. Affirmative defenses. Here, the defendant admits to the act but argues they should not be held criminally responsible. The burden of proof for affirmative defenses varies. The defense often must present evidence, and the prosecution must disprove it beyond a reasonable doubt. Common affirmative defenses include: 1. Self-defense. A person may use reasonable force to defend themselves from an imminent threat of unlawful force. The key elements are: imminence, the threat is happening right now; proportionality, the force used must be proportional to the threat. You cannot use deadly force to stop someone from stealing your lawn gnome. Reasonableness, the belief in the need for force must be that of a reasonable person in the same situation. Note: stand your ground laws in some states remove the duty to retreat before using deadly force. 2. Insanity. This is not a medical term but a legal. It focuses on the defendant's state at the time of the crime. The most famous test is the Knighton rule. Did the defendant know the nature and quality of their act? If they knew what they were doing, did they know it was wrong? A successful insanity defense leads to a verdict of not guilty by reason of insanity, which results in commitment to a mental institution, not prison. 3. Duress. The defendant committed the crime because they were threatened with imminent death or serious bodily harm to themselves or another, and a person of reasonable firmness would have been unable to resist. Duress is generally not a defense to homicide. 4. Intoxication. This is a complex defense. Voluntary intoxication, getting drunk or high on purpose, is generally not a defense. However, it can sometimes be used to negate a specific rea. For example, if a crime requires purposeful intent, voluntary intoxication might show you were too drunk to form that specific intent. Involuntary intoxication, being drugged without your knowledge, can be a full defense because the actus reus was not voluntary. Let's walk through the process very quickly. 1. Investigation and arrest. Police investigate a crime. If they have probable cause, a reasonable belief that a crime was committed and the suspect did it, they can make an arrest. 2. Initial appearance and charging. The suspect is brought before a judge. The prosecutor decides whether to file formal charges. The defendant is informed of the charges and their rights. 3. Grand jury or preliminary hearing. In felony cases, A judge or grand jury reviews the evidence to determine if there is probable cause to proceed to trial. 4. Arraignment. The defendant is brought to court, enters a plea, guilty, not guilty, or nolo contendere, and a trial date is set. 5. Pretrial motions. Both sides file motions, often to suppress evidence that was obtained in violation of the defendant's constitutional rights. 6. Trial. The prosecution presents its case, then the defense. The judge instructs the jury on the law. The jury deliberates. A verdict must be unanimous in a criminal case. 7. Sentencing. If found guilty, the judge determines the sentence based on statutory guidelines and the facts of the case. 8. Appeal. A convicted defendant has the right to appeal to a higher court, arguing that legal errors occurred at trial. Criminal law is a dynamic and contentious field. It forces us to grapple with fundamental questions. How do we balance the need for public safety with individual liberty? How do we ensure punishment is proportionate? What role should intent play in determining blame? The principles we've discussed today: legality, the burden of proof, the separation of actus reus and mens rea, are not just legal technicalities. They are the pillars of a system designed to ensure that the state's ultimate power is exercised, and justly. Hypothetical 1. Diana is walking to her car in a dark parking lot. A man jumps out from behind a van, pointing a finger in his jacket pocket that Diana believes is a gun, and yells, "Give me your purse or I'll kill you." Fearing for her life, Diana pulls out her own legally concealed firearm and shoots the man, wounding him. It turns out the man was unarmed. The man is charged with attempted robbery. Diana is charged with aggravated assault. What defense would Diana raise? What are the elements of that defense? Does the fact that the man was actually unarmed defeat her defense? Why or why not? Hypothetical 2. Tom and his friend Joe decide to go keying cars, scratching paint with a key. They go to a mall parking lot at night. Tom tells Joe, "I'll do this one. You watch for security." Tom keys a Mercedes. Unbeknownst to both of them, the owner of the Mercedes is sleeping in the back seat. The owner wakes up, sees Tom, and has a fatal heart attack from the shock. Tom and Joe are charged with murder. What is the actus reus of murder? What is the mens rea? Did Tom and Joe have the required mens rea for murder? Could they be guilty of a lesser crime? If so, what would the prosecution have to prove regarding the owner's death?